As promised, we are now joined by Todd Lutsky from the law firm of Cushing and Dolan, and this is Ask Todd, which is your chance to ask Todd your questions about your estate plan. The studio number here is 888-205-2263. Again, that is 888-205-2263. So get calling if you have a question that you want to ask Todd live on air. Again, 888-205-2263. 263. Mr. Lutsky, how are you today?
I am doing okay, except for my back. Otherwise, I'm okay.
Are you setting me up here?
Nope. Just my back hurts. Just complaining.
There's
I'm
no,
just complaining.
There's no setup here.
Nope, just complaining.
Okay.
All right. Just wanted to complain.
Cool, man.
I'm just making sure.
You asked me how I was. I had to tell you.
Well, I've been struggling with something myself.
Oh, yeah?
I have this problem. I compulsively steal ladders.
Really? That sounds like a problem.
I'm working on it and taking steps, though.
Oh, that's good.
So we're getting there. Todd, let's talk a little bit about the ownership of real estate. Specifically, I want to talk a little bit about primary residences first.
Okay.
A lot of people have the idea that if you have a declaration of homestead on a primary residence, that it provides some type of protection of said residence. How does that actually work, and what does it actually do?
Yeah, it does. And folks, the homestead here in Massachusetts, if you're listening in other states, please check your statutes. They do have homesteads in many states and may or may not be the same as this one. So the homestead here in Mass gives you protection from creditors of up to $500,000. Now, you need to be an owner of the property in order to get that. So, but owners can be joint owners, tenants by the entirety owners. They can be a life tenant. You can actually give away the property, reserve a life estate and get it. You can be a tenant in common. And this is most important, you can be a beneficiary of a trust. Now, for the longest time, until these regulations came out, these aren't overly new, but for a very long time, if you put property in a trust, you would not be considered an owner anymore, and you would not get the homestead. Now, you still can get the homestead when you put the property in a trust if you're the beneficiary of the trust.
What groups are included in terms of creditors? When you say it protects you from creditors, what's included in that, what is not?
And I think a fair example here would be, let's talk about what's not, because most creditors you're protected from, up to $500,000 of equity in your home. One big one that you're not, and it's actually carved out right in the statute, it says that, it's not going to apply, is nursing homes. In other words, if you have a lien by MassHealth on your property due to getting Medicaid benefits, then you are not covered. Right? I mean, it's very clear.
Yeah.
It's right in the statute. So,
yeah.
And the reason I want to focus on that is because many people will hear this and say, oh, that's great. $500,000 of equity is protected from my house. That maybe I don't need to do anything for nursing home planning. No. Just because you get the homestead doesn't mean that your house is protected from the nursing home. You need to do more planning than that. So that's the big one that's not listed.
Folks, the studio number here is 888-205-2263. That's the number to call if you want to ask Todd a question about your estate plan. Again, it's 888-205-2263. So someone listening says, okay, gee, I thought, maybe the homestead would help me, but instead, I want to protect my primary residence. Let me just gift it to the kids. Get it out of my estate. Good, bad, or ugly?
I think that's even worse. I don't think that's ugly. That's bad and ugly.
Okay.
I think it's both.
Why?
Folks, when you start giving away real estate, you are creating not only creditor problems by putting it in the hands of a child, you're losing control over your asset. You can't do anything with it. You can't sell it. It's not yours anymore. How do you replace it? How do you move? You're creating, and actually, here's my biggest issue is many people say, I'm never moving and I'm happy my kids got it. I feel so good. You know what you've just done? Likely, if you bought this house a long time ago, you've given your kids a huge capital gains tax liability. Here's the gift, right? When you go to sell it, you're going to be trapped. All the capital gain built into that property over the years, you've just given to them, and they will pay the tax when they sell it. That's probably the biggest problem. So please don't do that, folks. You got to really learn how to own your real estate.
As promised, we're going to go right to your calls with Todd Lutsky. Let's go to Phil on the Cape first. Phil, you are on with Todd.
Hi, Todd. How are you this morning?
Very well, Phil. What's up?
I'm talking about 7 properties. 4 of them, these are all in a trust.
Okay.
4 of them are rental income, and 3 of them, one I use for my own personal residence that is in the trust, and 2 other buildings that I use for just personal storage that's in the trust. My question is very simple. The house that I'm living in, it's in the trust. Can I get the trust to pay the insurance and the taxes on that property that I'm living in?
Is the trust that you own, is the trust a revocable trust or an irrevocable trust?
Irrevocable.
Irrevocable. Are you the trustee?
No, my daughter handles it or whatever.
Are you?
But yes.
Are you?
Yeah, it's in a trust for my family.
Right,
yes.
but the trustee of the trust is the one who controls what's in it. You don't know who that is. It's not you, or it's your daughter.
No, it's my daughter. Yeah.
And are you married?
Yeah.
So do you have 2 trusts? Because 7 properties seems like it's going to be a valuable estate. It's going to be, 7 properties in Massachusetts can be a lot of money.
Yeah. No. It's 2 trusts. One for my wife and one for me.
And they're both irrevocable.
And they're both irrevocable.
All right. So the answer is there's probably got to be some money in the trust, I would hope, like bank accounts to receive the rent, and maybe you put some investment portfolios in the trust. Is that the case?
Yeah. Yes. I'm just wondering, like, my daughter tells me I got to pay for the taxes and the insurance on the property that I live in, the house that I live in, which is in the trust.
I understand.
But she says
there's
no rental income.
Yeah, but it's an asset of the trust. So any money in the trust can be used to maintain any asset inside the trust. So you could use the money in the trust to fix the roof, the windows, pay the real estate taxes on any of the properties. I don't think it matters that one is a residential and one is a rental. They still all have a value and they still all need to be maintained. So I don't have a problem with the trust using trust money to pay those bills. Plus, you should check with your daughter. I mean, obviously you have the power to probably remove and replace your daughter. I mean, you should still be in large part in control of these irrevocable trusts if they're drafted right. The bigger problem I have is that you've got 4 rental properties inside a trust when I would say those need to be in LLCs. Otherwise, you're running the risk of creditor problems from lawsuits, right? If someone gets hurt on any one of those properties, they're going after all these assets in the trust. I think that those properties should be conveyed out of the trust to an LLC, maybe 1, maybe 2, maybe group them depending on how you want to do it, and take back stock into the trust. That way the lawsuit is against the LLC and not against you guys sort of personally, or really going after all the assets in the trust. So think about that aspect of it, but I hope I've answered your question. And folks, that might give you a little bit of a insight into our new guide, which is Real Estate, Who Owns It and How It's Protected. Probably my favorite guide because it's so appropriate for so many people. How do you own real estate? We just discussed it. Could it be owned in a trust? Yep. Could it be owned in an LLC? Maybe. What kind? Rental property? What are the ramifications of owning it in an LLC? What if we own it jointly? Most of you are married. If you're married and you own it jointly, is that the right way to go? Is it tenants by the entirety? Should we ever put as Chuck asked earlier, should we ever put our kid's name on a piece of rental property or on a deed? Folks, there's so much to learn about creditors, control, taxes, etc. Call Get the Guide, Real Estate, Who Owns It, and How It's Protected, 866-848-5699, or legalexchangeshow.com. You can download the guide there. Again, 866-848-5699 or legalexchangeshow.com.
Todd, we've got another question for you. This one comes from Alex in Topsfield. Alex, what's your question for Todd?
Yeah, it's about Homestead. My husband I think he put a homestead under his name.
Okay.
Would I be protected? If you don't know, I can.
How old are you?
Too old.
Over 62?
Yeah, way over.
Okay, well, it's important.
Yeah.
Do you live in this house together?
Yeah, forever.
Okay,
Yeah.
good. So is the deed to the property only in your name, or is it in joint names?
Both.
So
Yeah.
it's got both your names on it?
Yeah.
All right, so this is important, and it's good for everyone to hear this, right? So the homestead protection applies to owners of a home, okay? And owners of a home is defined many ways, one of which includes joint ownership, which is what you've got. So you've got joint ownership, so I know you're covered as an owner, and you're considered a family member as well. So now, as joint owners, you would get a $500,000 not exclusion, but creditor protection. So, but you need to file, right, to get that. So if he filed only, then he gets $500,000 of protection. But if something happens to you and someone sues you, there's still $500,000 of protection because you're a member of the family. Okay, so even though you didn't file, you'd be covered under his $500,000 family exclusion. And for folks who don't do anything, don't file anything at the Registry of Deeds, remember you got to pay $35, file a little form at the registry, and you're covered. If you do nothing but you're a homeowner, you get $125,000 of protection just for being an owner, even if you've done nothing. The reason I asked, though, about the age, folks, is for people 62 and over, married, maybe even if you're not married, it doesn't matter. You could be two older folks, perhaps, who have lost their spouses and maybe they've found each other and they're living together now. So even if you're not married, if you both file, you both get a $500,000 capital or a $500,000 of creditor protection on your house. When I say both, after 62, you actually can stack them. So you get $1 million of creditor protection. So if I was you, I'd get out and file so that you get your own $500,000 of protection. That way, if either of you are sued, the first $1 million of this property, of equity in this property, would be protected. Remember, when you're just a family member and you're under 62, it's limited to that $500,000. There's no stacking involved. So lots to learn about in real estate and homesteads and how you deal with real estate. So there you go. Hopefully that was helpful.
Mr. Lutsky, thank you so much for joining us today.
It's always a pleasure.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing and Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. Evaluating how to smoothly pass along assets to your family is a huge part of a solid estate plan. Your home is most likely your primary asset, and if you think simply transferring it to your kids is the easiest way to go, you'd be taking a major risk, especially if they divorce in the future. Don't put yourself in an awkward position of having to buy back your own home just to protect it from creditors. Get Cushing and Dolan's brand new guide called Real Estate, Who Owns It and How It's Protected by calling 866-848-5699. There are better ways to own your real estate, and this guide will walk you through the process step by step, answer any questions you have, and put you in a more advantageous position to avoid probate down the road. Don't put your home at risk. Call today at 866-848-5699 and ask for your free guide, Real Estate, Who Owns It and How It's Protected. That's 866-848-5699, or you can request the guide online right now at LegalExchangeShow.com.